a motion to continue the case. We each filed a motion to continue the case, Your Honor, and I would like to discuss the reasons behind our motion to continue. Oh.
Well, the motion to sever from Batey also included a motion to continue trial date. So it's in with the motion to sever.
And I believe that they filed a motion to continue, Your Honor. I could be wrong. Your Honor,
We actually filed a motion to adopt their motion to sever and continue trial date.
Okay, you did.
Your Honor, at this time we're making a request to continue the trial, which is set to begin on November 30th. Your Honor, since acquiring our expert witnesses and having the opportunity to have detailed and meaningful discussions with Dr. Lippman, we have learned, Your Honor, that and he has advised us, strongly advised us, to seek additional testing. The additional testing, Your Honor, would be on Ms. Lackey's underwear and the vomit that was collected by April Bramlage, who testified for the state last time. It is our understanding from Dr. Lippman, Your Honor, that sweat could be on the underwear, which would result in the sweat leaving chemicals, specifically drugs that may have been used, and traces of that would be on the underwear. Additionally, Your Honor, the vomit was not tested for drugs, the underwear was not tested for drugs, and it is our understanding from our expert, and again, he has strongly urged us to test the vomit for drugs that were used, may have been used by Ms. Lackey. What are we doing with the last name, Your Honor? I believe we used her last name last time, and I don't want to violate any. We haven't really discussed that, but I use her name.
Say alleged victim.
Okay. So, Your Honor, given that and given her testimony at trial, where she testified that there were no drugs ingested, there was discussion of, I believe there was marijuana. She admitted subsequent to that using marijuana, but denied using marijuana prior to that time. So based on that, Your Honor, we believe that testing the underwear, testing the vomit would be imperative to our case to assist us in making determinations about what, if any, drugs were used by Ms. Lackey at that night specifically. Oh, and Your Honor, we also did not mention, we asked about getting the results. Dr. Lippman did call, and it would be after November 30th, and we would be using MNS Labs, which I believe has been used by the state in this case.
Let me try to be clear about this. You're saying that if there was additional testing, then the results would not be back until after November 30th?
That is correct. And of course, the state would have the option at that time to test or retest additionally, Your Honor, if they liked. So that would be the basis for the continuance.
Well, let me hear it.
Your Honor, please, as regards to Mr. Vandenburg's motion to continue the trial date, we're in a different position than Mr. Robinson, Mr. Batey, in that we weren't original trial counsel. We didn't represent Mr. Vandenburg at trial. And we weren't given that year and a half to get this matter ready from trial from when Mr. Vandenburg was originally indicted. The court's made a ruling today that there's a new superseding indictment, and that superseding indictment is going to be the indictment. I assume the state still has the other indictment pending. I don't know what they're going to do with that, but I'm assuming we're going to trial on the superseding indictment and not the original indictment. But given that, Your Honor, please, when this trial date rolls around, November the 30th, and jury selection beginning November the 16th, my firm and myself and Mr. Reagan will have had 4 months to get this matter ready for trial, on top of cases that were pending prior to our involvement in the Vandenburg matter. One of those cases is an aggravated sexual battery that I have scheduled for trial on November the 4th. It is a 2011 case. There are 6 different counts of aggravated sexual battery. There are 2 different alleged victims in that case, and I have been told that we are trying that case. Motions on November 2nd, trial again November the 4th, and we are going to try, they're severed, we're going to try those cases back to back so long as we can get juries selected. That's a 2011 case. I've attempted to move that case. It will not be moved. We were made aware of that last week. But on top of that,
How long do you anticipate those cases?
I anticipate 3 days per victim. There's 2 alleged victims, so it's a total of 7 days. I would suspect 3 days at a minimum, maybe 4, but I wouldn't suspect more than 4, Judge. And that's a 2011 case. It's a Jefferson County Criminal Court case, and I was told just last week that that case is going and it will not be moved. On top of that, Your Honor, please, we have and continue to work very diligently to provide Mr. Vandenburg with the best zealous legal representation that we possibly can. We have been given more than 1,600 pages of a trial transcript. We've been given more than 1,600 pages of document discovery. We've been given over 20 gigs of data, and I don't really know what gigs of data mean, so I have to rely on
I'm in the same boat.
as experts. And just to give an example, that can equate to several different things. It can equate to about 41,000 documents. It can equate to 120 hours of video. It can equate to 17,000 pages from the web. It can account for 731 hours of surveillance. So we can break it down, and there are all of those things combined in that 20 gigs of data. And we're just not going to be ready on November the 30th to try this case. I mean, we're working hours, and we're working through the night, and we've got other cases to prepare, and it is my belief that someone's not going to get the legal representation they signed up to get. It's my belief that at some point in time, we're going to have to take from Peter to pay Paul. We're going to have to, and I don't mean that in terms of monetary, I just mean that in terms of time. There's so many hours in a day, and there's only so much we can do. And our Supreme Court and the Supreme Court of the United States say that the defendants have a right to choose their lawyer, and we're working really hard at this juncture. Again, just to repeat, we're not going to be ready for trial on November the 30th. We have identified some experts that we use internally, not necessarily experts that are going to provide testimony that help in the sorting of digital data and the review of digital data and those types of things. And they're also in the process. I don't know that they get through what they need to get through. We still need to go view evidence. We still need to go view cell phones. And we're, 2-3 weeks before we start picking a jury in this case, Judge. So I respectfully request that we be given, some courtesies that were given to prior counsel. I don't know that I'm asking for 1.5 years, but I know I'm asking for more than 4 months to try this case. And I ask the court to, before we get too much further down the road, to give us the time to adequately prepare Mr. Vandenburg's case, serious case, Judge.
All right, State's response.
Your Honor, in response to Mr. Robinson's motion to continue that was filed with the court, Mr. Robinson has been fully aware of all of the evidence in this case for over 2 years. He has not only participated in the trial, but he also has a complete trial transcript. There is no new evidence in this case. Mr. Robinson hired Dr. Lippman approximately 1 year ago from today. Dr. Lippman has been advising Mr. Robinson as part of Mr. Batey's trial team for that entire year. The request that Dr. Lippman has, I'm assuming, recently advised them that further testing could be done doesn't really make sense to the state of how this could be an issue that just came up. All of this evidence was known to them a year ago when Dr. Lippman became involved, which there are a couple of things that Mr. Robinson said that I don't believe are actually correct. He made a statement that he wanted to have the underwear tested as well as the, I'm assuming he's meaning the crusty material from the tub that he's calling vomit tested.
That's what I assume.
Which defense called April Bramlage from the TBI actually as one of their witnesses at the trial in November. She testified that she did test that substance. It was tested for drugs, and there was a result for that test. And she said that no testing for alcohol could be done. Now, it wasn't provided to the state attached to the motion. I don't know if there's an affidavit from Dr. Lippman explaining what the testing is that he's recommending. The state doesn't know of any testing that actually could be done and what the purpose of that testing would be. If Mr. Robinson is trying to locate evidence that would show that the victim in this case was actually drugged, I believe that they do have to have a good faith basis for making that request of the court and for asking for a delay in this trial to have testing, and it just seems outrageous to the state they would be asking for this testing to be done at this late date. So the state would ask that that motion to continue be denied based on that, as well as if they are going to request that further testing be done, the state would ask that more information be provided, whether it be through an affidavit, but some information that gives a good faith basis for why this testing should be done. Could it be done? I don't believe that we even have information before the court that this is testing that can be done and what result could ever come of it. So I don't think that that is a valid reason. I think that it's a delay tactic on the part of Mr. Robinson just to obtain a delay in the trial in this case. And further, specifically as to the vomit, there's no way to determine whose vomit that was on the crusty tub. I believe at one point Mr. Vandenburg made a statement that he vomited. The vomit wasn't collected for 3 to 4 days. There's no way to determine exactly whose it is. So again, I don't know that it's been presented to the court that there is a rational reason to be requesting this testing be done. As it applies to Mr. Vandenburg, which again the state does not have in its possession a motion to continue for Mr. Vandenburg, Mr. Vandenburg adopted Mr. Batey's motion to sever and motion to continue. Again, Mr. Batey's motion states that he has a request for further testing to be done. Mr. Vandenburg Mr. Vandenburg is not in court today. However, his attorneys come to court today stating that they have a litany of reasons requesting a continuance. Specifically that they need more time, that they were just retained approximately 4 months ago, which it will be 5 months by the time we get to the trial date. However, Mr. Vandenburg is the party to this case. Mr. Vandenburg retained trial counsel. He has had Mr. Albert Perez as part of his trial team from the very beginning. It will be 2.5 years when we go to trial that Mr. Perez has been involved in this case. Additionally, Mr. Vandenburg hired Mr. John Herberson and Mr. Fletcher Long, and then Mr. Vandenburg made a decision to fire his trial attorneys. That was Mr. Vandenburg's decision. Then Mr. Vandenburg makes the decision to hire Mr. Reagan and Mr. Boland. They came into court, they made a notice of appearance, and Your Honor made it extremely clear that this case would be tried this year. They knew exactly what the time frame was when they accepted him as a client. The trial date for this case was set months ago. Again, they were in court and made representations to this court that they would be ready for that trial date. And any other clients that they have, any other conflicts that they have, they made that representation to this court and they have known about it. This is not something where they have 20 gigs of data that must be gone through that no one's ever looked at. Mr. Vandenburg has come into this court, filed motions, and we've had hearings about his experts that have reviewed every single minute of the surveillance video, that they have reviewed every single piece of information. It's been made very clear to this court that Mr. Vandenburg's defense counsel has gone through everything. And again, Mr. Albert Perez, who's been part of his trial team for 2.5 years, is still involved in this case. I think it's inappropriate for Mr. Reagan and Mr. Boland to come into court and ask the court to continue it for that reason. So the state requests that the court deny both motions to continue. For those reasons stated, but additionally, a paramount concern is that this court has set aside at least 2 weeks for the trial in this case. Again, this has been scheduled. It's been scheduled with the state's attorneys. It's been scheduled with the defense attorneys. Your Honor has gone to the lengths to schedule an out-of-city vernier, scheduling the court, scheduling all of the parties involved to go to Chattanooga November 16th. The scheduling that has been set in stone by this court on multiple occasions has not changed. But of even greater importance is that there is a victim in this case. That victim was notified of the trial date. This isn't a trial date that's going to take 1 or 2 days. This is a trial date that will most likely take 2 weeks. The victim in this case, who has already gone through this before, has scheduled her life around this. And the victim has a right to a speedy trial. And asking that this court continue the trial is not only disrupting the court schedule, but it is disrupting the life of this victim. And the state, again, respectfully requests that those motions be denied.
Response?
Your Honor, I want to clarify some statements that I believe were not correct. Ms. Norman, specifically the vomit, Your Honor, April Bradley in court, she testified that she did not test that. And it was put into, I believe, water or a solution, so it's a liquid substance now. And what she testified was that she couldn't test it for alcohol, just like Ms. Norman just said. Ms. Norman said the word alcohol. I don't want to test it for alcohol, Your Honor. I want to test it for drugs. And Ms. Bramlage testified when she was here that she did not test it because the TBI does not do that testing. They would have to send it off. So they sent it back to the state, and the state elected not to test it. So we didn't find out until the trial that it could be tested, or perhaps should have been tested. But in speaking with Dr. Lippman, who was hired in the first trial for the specific purpose of determining or estimating blood alcohol level, that was his sole role. His sole role was not anything outside of that, Your Honor. But in speaking with him, he has encouraged us to test the vomit have it tested for drugs, as well as the underwear, which we had no idea until speaking to Dr. Lippman that underwear would have sweat, and the sweat would show evidence of the ingestion of drugs. Now, the state argued at trial, it came out, I believe, from Ms. Bramlage herself, there was a suggestion that that there was a blue drink, and then a suggestion that Ruhibinol has a blue marker to distinguish it. And that's all that was said, but certainly the suggestion of that is the argument, of course, they want to, is a suggestion that perhaps it was without saying it. So testing the vomit and testing the sweat would show markers for that. Your Honor, I suppose if Your Honor requested an affidavit, I certainly don't bring this argument in bad faith, but I'm making the argument in good faith. If Your Honor wanted something from Dr. Lippman, I'm not required to give my defenses or make my defenses available in court, but I basically said everything that I'm trying to do and making this argument in good faith that this vomit was available for testing. The state elected not to do the testing. Dr. Lippman believes the testing is important of the vomit and the underwear, and we're asking the court to allow us to do that, which is going to result in this case being continued because the test results will not be back until after November 30th.
All right, so briefly, Judge, just to clarify, Your Honor, please, when we were last in court and Your Honor asked that we discuss a trial date, I didn't represent to the court we would be ready. I represented to the court. As a matter of fact, I asked the court to schedule this trial at some point in time after the first of the year, and the November the 30th date was and I think I'm correct, I could be wrong, November the 30th date was the last date on the court's calendar for this year. And I represented to the court, is that we will try our best to be ready. And I expressed to the court that I don't think we can, and the court said, so you're telling me you can't be ready in 4 months. So to suggest that I said, or that Mr. Reagan said, we will be ready, I think is not true. The representations of Mr. Vandenburg firing his trial counsel, I don't need to belittle other lawyers. I don't need to talk about lawyers being suspended, lawyers being disbarred. I mean, that's just disingenuous to make a comment like that. Mr. Vandenburg retained counsel that was to replace his other lawyers. As it relates to Mr. Perez has been part of Mr. Vandenberg's defense team. Mr. Vandenberg would be left without 2/3 of his defense team, or at least 2/3 of his defense team not being prepared. We're trying hard, Judge, and we just ask this court to continue the trial date to a date in the future, Judge, please.
All right, well,
May I briefly respond? I apologize. Specifically in response to Mr. Ward
go
Robinson.
ahead, please go to the podium.
Well, and maybe if I could move the microphone, but I was wanting to read something from the trial transcript that I had brought up on the screen.
Okay, well, out of my court office, we'll do something.
Thanks, sir.
You're welcome.
Mr. Robinson was specifically stating that April Bramlage did not test the vomit material for drugs. However, the trial transcript from page 1601 and 1602, the question is to Ms. Bramlage, is in Exhibit 00AA is the crusty material tub from the tub on floor beside closet. Could you tell us what your analysis for those? She said, I found no basic drugs detected, and the sample was presumptively negative for barbiturates, benzodiazepines, cannabinoids, cocaine, opiates, and negative for the selective benzodiazepine test. I think that makes it very clear that it was tested for drugs. The crusty material has been tested. She went on to state that no alcohol test could be done on that substance, but that she did test it. So again, I think it's disingenuous of Mr. Robinson to come into court and request a continuance asking that testing be done that has already been done, that there was testimony at the trial that it was done. Again, Dr. Lippman, he is not a DNA expert as far as the state has been informed. He doesn't have an expertise in that area. But yet Mr. Robinson is saying that it's Dr. Lippman is the one who is recommending further DNA testing. And he is saying that there is somehow that sweat could be detected and then you can test that sweat for drugs. I am not aware if that is true. And I don't believe that there is information from the court stating that this testing of the underwear could even be done. And the testing of the vomit has already been done. So again, the state is asking that that motion be denied because I do not think that there's any basis for it. Which again, Your Honor, the testing saying that they want to test for drugs, there was abundant proof in the evidence and that came before the court during the trial that the victim was unconscious. So again, I don't believe that Mr. Robinson has stated any actual relevant reason to ask for further testing be done on either of those items. And as far as Mr. Vandenburg's response to the motion, again, this is retained counsel of his choosing. This is not appointed counsel in this case. I know he brought up the reference to Mr. Fletcher Long, Mr. John Harbison. Mr. Harbison is, there's no issue with any suspension related to him. At the time that Mr. Vandenburg fired Mr. Long, he had his license. Again, these are all decisions that Mr. Vandenburg made. And the state's position is that when they made a notice of appearance on this case, the court made it clear that the retrial would happen this year. So the fact that they made the notice of appearance, they are saying that they can be ready. Mr. Vandenburg is not entitled to 3 attorneys. He's entitled to a defense. He has chosen to hire 3 attorneys. One of his attorneys has been on this case for 2.5 years. And again, the state feels that there is absolutely no reason why Mr. Reagan and Mr. Bolin can not be ready for this trial date.
Just in response, I believe your Honor's comment was you would like to have this case tried by the end of the year, not that it was, and I think we all understand that your Honor would like to do that, but Ms. Norman's summation is not, I don't think, an accurate description of what you stated, Your Honor. And just in closing, Your Honor, Ms. Norman talked about further testing for DNA and Mr. Lippman not being a DNA expert. And it's not for the DNA, Your Honor, as much as it is. I believe if you continue reading, and I don't have the transcript in front of me, but it talks about, I believe, presumptive testing, but I don't think it was the gas chromatograph golden standard testing, Your Honor, and that the samples were actually given back to the state to do additional testing, to do that testing, and they did not. So, with that said, Dr. Lippman has stressed the importance of doing the testing, and we rely on our experts, and we are following his advice, making this argument, Your Honor.
All right. Bowling or Mr. Reagan?
Judge, only I just bit brief, but Ms. Norman has brought up the names of Mr. Long and Mr. Herbson. I'm sure the court will recall Mr. Herbson was suspended during the trial of this cause. Mr. Long was convicted of extortion. I believe that was in either May or June. And that was even before we had the ruling on the motion for mistrial. So he would not have been available for a retrial in any event. And as far as the number of attorneys that worked on Mr. Vandenburg's case, I would simply note that there are 3 of them sitting at the state's table, young pleas. Like to even up the odds.
Okay, well, what my thinking is right now is with respect to Mr. Batey requesting a continuance, the court is not inclined to do so because Mr. Batey's counsel has been available and around and ready this entire time. With respect to Mr. Vandenburg's attorneys, the court is still thinking about that issue. That is their request for continuance. The court is thinking about that issue and will rule on that this morning before we leave. The court is considering several matters, and I must say that I do recall Mr. Bowling bringing up the issue of having trials set just prior to this trial date. And but anyway, I'll rule on that this morning. All right. What other matters do we have?
Judge, just briefly, we had filed a number of other motions, and the disposition of those will probably depend upon whether or not you're going to grant the continuance. But we did file a motion for exculpatory evidence, a motion to require the state to reveal any agreements or concessions to witnesses.
In all of those matters, I do believe the state has responded
Yes,
to
sir.
and have provided that information throughout this process. I don't think there's any additional information that the state has.
No, yeah, just as soon as we give a written notice.
Right.
And they responded to our motion, and that was what they said in their responses. I just wanted to get those cleared up before the court takes its recess. And we had filed a motion to suppress or in the alternative in limine. I would assume that motion is going to trail along with the other motions to suppress that were held in advance this morning.
And motion to suppress is dependent upon the information that I have.
Yes, sir. Yes, sir. And we would file a motion for jury questionnaire again. That will depend upon whether or not we go to trial in November. I can have a proposed questionnaire to the court by Friday if we're going to still go on the 3rd.
Well, I would like that.
I mean, on the 16th. Yes, sir.
All right. Just I'm not saying that I'm going to allow it. But
Yes, sir.
I would like that. Because, I thought about that this morning, and how my thoughts were that if I did allow the written questions, that those questions would be done the morning that we first were here at the jury, and you would be provided with them that very morning, so that in the voir dire process, you would have that available to you to use, rather than having, in a death penalty case, we do the written questions much prior to the voir
Yes, sir.
dire, and then you have a lot of time to review it. But in this case, I think it would be very specific if you had questions, and I don't think it would be that lengthy. But so, having said all of that, I would like to see what you propose.
Yes, sir.
Before I allow or deny the questionnaire. And I know the state's position is that there is no need for a jury questionnaire, but I would like to see them.
Yeah, and we're not going to propose a lengthy questionnaire at all. It's going to be, as you said, very specific, and given the history of this case, I think it will be very helpful.
All right.
Both sides.
We don't have any objections, as long as it's 1 or 2 pages or something they can fill out quickly, we can review all it. they're actually.
Right, and that's what I was thinking.
You
it
get
would be
into
done.
10, 15, 20 pages, it's going to be a nightmare.
Not gonna allow that. Okay.
And that was going to be my argument too, Your Honor, about the appropriateness of doing a jury questionnaire, given the sensitive nature of some of the questions, especially given juror number 9, and I do believe it is a very sensitive issue for people, and they would feel some restraint and apprehension of discussing a prior sexual touching or inappropriate touching in front of people they don't know, and my argument would be that, again, something, I figured probably less than 8 questions that just get right to the point.
I don't know if Mr. Reagan is thinking about 8 questions, but I understand.
Maybe a little more than that. But Judge, we had also filed another motion that will probably depend upon the court's ruling on the motion for continuance as a motion for leave of court to file additional pretrial motions.
All right. Anything else? Otherwise, I do want to take just a short break and think about these matters. Yes.
Well, please, obviously, we're opposed to filing other pre-trial motions. Like I say, we're going to be 2.5 years. By the time we get to trial, if we go November 30th, I think we've spent days and days and days pre-trial motions in this case, and they've all been addressed. Now, the state has filed some motions in limine. I don't know if Your Honor wants to hear those now or not. They're pretty short. I think we've got an extra copy. Here's an extra copy, Your Honor.
Judge, do you have any responses that we filed?
I haven't seen it.
I'd email them to your assistant, I guess.
I didn't check my email this morning, but
Okay. There are just 2 of these.
2 motions in limine, and I think we supplemented some case law on an issue. These are all just about issues that came up in trial, Your Honor, please. The first one was just, there were several questions I asked about the Vanderbilt hostess program during the trial. I think all the witnesses responded there wasn't a Vanderbilt hostess program. There wasn't a Vanderbilt hostess program, and never has been one that I'm aware of. And obviously, our victim was not part of a hostess program. That all came about, I think, by a statement she made that Coach Franklin had asked her if they were interested in maybe participating in one. That was a week before this attack. Nothing else was ever done. But there's no relevance as far as whether there's a hostess program at Vanderbilt trying to indicate she's some kind of hostess / whatever you want to take from the word hostess. But I don't think that's relevant. We went through a lot of questions on it. It wouldn't be relevant if there was a hostess program, I don't think, but there's not one. I think there's no basis in the record for asking, since all the witnesses said there was not a hostess program.
And now that I looked at your motion, I actually saw them last week.
Yeah.
I just forgot about them. But I
That's
saw
not a good
both of
thing.
them last week. All right, any response to number 9 about the hostess program?
Your Honor, the only basis for the discussion of the Vanderbilt hostess program would be the text messages from Coach Franklin to Ms. Lackey asking her to head up the hostess program, knowing and admitting that it would be against school policy to have a hostess program, but he was doing it anyway. Now, Your Honor, I think it's perhaps like the other motions in limine. Occasionally, Your Honor will just hold those pending and not let anybody mention it until it comes
Right,
time.
unless the door is open some kind of way which will allow that issue to come to fore.
Correct. And that would be my recommendation, that Your Honor just take these motions in limine. I mean, we can discuss them briefly, but at this time, I don't know that I would have any basis to introduce the statements from the text messages from Coach Franklin to Ms. Lackey, but I would be willing, as the state has been willing in the past, that prior to bringing anything like that up, having a sidebar in Your Honor's office to discuss. So my recommendation would be that we just leave these motions pending until it becomes relevant and Your Honor has the opportunity to, for an argument to be made why they would be relevant or introduced at that certain time.
Well, I just respond, I'm not aware of any text messages about the hosting program at all, because it didn't exist. I'm not aware of any text message from Coach Franklin to the victim in this case. But they're not relevant if they exist, but obviously because, there wasn't a hostess program.
I'm not aware of it myself. It may have come up, I don't recall specifically. With respect to this, well, let me let Mr. Reagan speak first.
Judge, and just briefly, we filed a written response, not on the block. But I did email a copy to the DA's office. But we've set forth in our response why we think questions about maybe not a quote hostess program unquote, but questions about the recruiting activities, these would be relevant to show how the alleged victim met Mr. Vandenburg and to establish their prior relationship before the events of June 23rd. That's why questions of this nature we think would be relevant. Maybe they didn't call it the Vanderbilt Hostess Program, but the alleged victim in her interview with Mr. Mayo on July the 8th, I think that was the date, July the 8th, 2013, talked about Coach Franklin coming to her and asking her to get a group of pretty girls to help recruit football players. So they may not have called it a hostess program, but it was a program where Vanderbilt co-eds met with football recruits in order to try to encourage them to sign with Vanderbilt. It may not have been called a hostess program, but apparently, according to the alleged victim in this case, a program like that at least was talked about, and we think it would be relevant for us to ask questions about that sort of thing.
Well, please, I don't think that's accurate. Anyway, as far as Miss Lackey, she didn't meet Mr. Vandenburg as a hostess. She met him in a bar where she was with friends when he was on his recruiting visit before he got this fight. He got thrown out of the bar. So, if they want to get into recruiting...
If we're going to get into this kind of thing, we're inserting extraneous prejudicial matters. I object to that.
I mean, if they're going to open up recruiting, and it's not relevant, Your Honor, please, that's what I'm saying. And that wasn't accurate. She wasn't a hostess when she met Mr. Vandenburg. And if they want to get into his recruiting and what happened, and that I don't think they want to do that. The state's not going to do that. But, you start getting at what's recruiting got to do with this case? Nothing. He was already an athlete at Vanderbilt when it happened. He'd been there for weeks. Recruiting has nothing to do with this particular case. They kept trying to go there, and that's why the state filed this motion. There are at least 4 witnesses who asked, do you know about a hostess? No, there's no hostess program. That conversation was had with Coach Franklin a week before this happened. After it happened, obviously, she wasn't in any condition to do a hostess program. There wasn't a hostess program when he found out that he couldn't use dance team people because they're athletes. And that's where it stands. But there's nothing relevant in this case about football recruiting or hostess programs or anything else. He was already there. It wasn't on a recruiting visit. It has nothing to do with that. If he wants to testify he met her as a hostess, he can do that, obviously. But that's not Miss Lackey's testimony if you review the transcript.
Well, I think the defense would have the right to inquire about how the two met. I think that, but with respect to any issue about a bar fight and getting kicked out of the bar and that kind of thing, I don't know about that.
Well, the state's not going to put that in if they get in the night she met and it was people in a bar meeting football players that are being recruited, yeah, they're friends, they're Vanderbilt, they do that kind of stuff, I guess. But it's not a hostess program.
Right, I
If
understand
you
that.
wasn't an official employee of Vanderbilt hostess program, or anything like that, they can get into how they met, that's not a problem. I just don't think it's like you stated before.
Okay. All right, number 10 is Leal, Barbara Leal. How does that pronounce?
Leal, please.
Okay.
That's the woman, you remember the issue on the single sperm head recovered on the panties that were recovered several days after the attack in that particular case. And we had a very lengthy, I think half a day, 412 hearing on that issue, and Your Honor ruled it wasn't admissible, that there was no consent had been raised, so it wasn't relevant evidence. We got into the trial, and Mr. Long raised in the middle of the trial the fact that Mr. Vandenburg was charged with destruction of condoms, that he felt that would be some kind of evidence that a condom wasn't used, possibly. And the court allowed that evidence only as to count 8 in the indictment. Since then, the superseding indictment does not have count 8 charging Mr. Vandenburg with destruction of evidence. There's a separate case charging with that issue. So that count was not resubmitted to the grand jury. So that count does not exist now. So based on the court's previous ruling under 412, we don't think Barbara Leal would be relevant as to the issue, as to the single sperm head that she tested. And we did attach part of the transcript to our motion.
All right, I see that.
Your Honor, my recollection of Barbara Leal's testimony was she came in and testified as an expert, and she was the one that detected the semen in the panties, and that she did test that. She was able to exclude Mr. Batey as a contributor to that single sperm head, but she was not able to exclude Mr. McKenzie, Mr. Prelue, and Mr. Banks. So that certainly would be probative and relevant to Mr. Batey's defense that there was sperm found, but it was not Mr. Batey's. So I thought at that time, Your Honor, the testimony, expert testimony of Barbara Leal and what she testified about was very relevant, and we would expect for that to continue to be relevant. As to Mr. Batey's defense.
All right, anything from Mr. Vandenberg?
Yes, Your Honor, we filed a written response. We just rely upon that response. It's my understanding that Mr. Vandenburg was also excluded in the sample that Mr. Robinson was talking about, but we would simply rely on a written response.
All right, well, this is something I'm going to have to take a look at before I make a ruling on it, because I just need to know what's in the record and what it relates to and what the response is to it. So I will rule on that. I don't know about today, but very soon. All right? Okay, let me take a short break and think about, well, before I do that, we have other issues that we need to discuss. Well, just let me know if we have other issues.
I was just going to go down my list, Your Honor, and the state did file responses and provide information. We did file a motion to exclude certain photographic images. I think,
but, you know, that's one of those that we've gone through specifically. I know Norman took very copious notes about that, right? And we went through all of that.
I agree. I'm not arguing for Mr. Vandenberg's attorneys, but they certainly weren't there when we went through those photographs, Your Honor. My request was going to be that we have a sidebar and walk through those photographs again sometime before we...
We can do that. I mean, we can go through it, you know.
That's all I'm asking, Your Honor. I'm not asking you to change anything today, and I don't want to go through photographs today. I just wanted Your Honor to be open to walking through those photographs again. I think for everyone's benefit, perhaps especially for Mr. Vandenburg's attorneys.
All right.
And I believe that's it, Your Honor.
Actually, I believe there's one more motion, the money issue.
Oh, yes, Your Honor. We filed a motion this morning asking the court, Mr. Batey was declared indigent. Your Honor did put...
About the GPS,
Yes, sir.
I glanced at that, I didn't read it. And Mr. Batey, is he currently employed?
He is not, Your Honor.
Well, I did receive notice this morning as well about some arrearages. I don't know how much they charge on these things. Do you know the daily charge?
Is it 80 per week?
Yes, sir.
$80 per week, Your Honor. And we're requesting that the balance be forgiven and...
Well, wait a minute. I'm just trying to calculate something.
Okay.
So $310 for October, and we've only completed less than 3 weeks. That doesn't add up. $310 for October, unless they're adding September and October together. Well, anyway, what I'm going to do is I will waive the future amount, but I'm not going to waive the current balance. I think that's something that needs to be paid.
Yes, Your Honor. We'll just ask if we can set up a payment arrangement
Okay, that'll be fine.
with the second floor, and we'll take care of that. Thank you.
I'll take a short break and I'll come back. All rise. Court's in a brief recess.
Let's get a copy of the response session that you filed.
Our responses,
Or did you email them to us?
yeah, I emailed them to the lady, but emailed some of the motions to me. I just thought that was the way you did it.